interpretation of national interest, which the bill purports to
Yes.
imply or implies, is far too broad. There is no interpretation of national interest. There are a few guidelines that it lists here, but what can be termed national interest goes a lot further.
Why you don't have any confidence in the courts? If it's wide, somebody will bring it to court at some stage and the judges will say. So why is it unconstitutional?
Well, that's even if, and in terms, according to what Justice Kuhn has pointed out,
Yes.
is that that's even if somebody wants to risk a 10-year imprisonment sentence or risk their career or their lives or the lives of their families for a 10-year imprisonment.
Are you then saying that the way the bill is phrased and framed and the architecture of the bill, that it would discourage people from disclosing sensitive information, and that is, my brother to the right's point, the penal sanctions of the bill?
Well, if I may point out,
Yes.
and if you'll bear with me, if you turn to the review process in sections 30 to 32, so when requesting for status review of classified information, because there are obviously procedures set out in this bill before one can take it to the court, there are legislative procedures.
Yes.
Sorry. Section 31 states that a request for review of the classified status of information must describe the document or materials containing the information or describe the category or subject matter of information with sufficient clarity to enable the head of organ of state to locate it with ease. My submission on this provision is that it's an entrapment provision. If we're supposed to describe classified information that the public or any other organ of state or anybody who doesn't have authority to access that classified information must describe what is in the classified information, the subject matter, the documents for which it is
Yes.
supposed to be in, with sufficient clarity, that's essentially giving ourselves away. That's saying that we have information, that you have classified information, and we know a sufficient amount of that information to describe it with clarity so that you may find it with ease. Read that section, read with section 45 of the bill.
But I would have that problem with most any information that I want to request. Either I know about it and I can, in which case I would want to request it, or I don't know about it at all, in which case I would just live in ignorance.
Well, that's the detriment to our democracy, are we to then live in ignorance of
What's wrong with that? People know far too much these days.
The ignorance of a democracy perhaps is unconstitutional in itself. We have founding provisions in Section 1 of the Constitution where our democracy is underpinned by openness, responsiveness.
You see, the bill was passed with the overwhelming majority of the representatives of the people of the Republic. The people wants this, whether it leads to ignorance or not. Your client says that it has a chilling effect. Now, in my view, when people know too much and trouble the judges with what they know, now that has a chilling effect. Now, what's wrong with the bill? Why should we strike it down as unconstitutional? The majority has passed it. It's gone through both houses. That's the democratic process. The government says we need to secure the national interests. Nothing wrong with that. Why should we, as a court, interfere?
Well, if a court is not going to interfere in where information is unduly classified or unlawful, then that raises the issues of separation of powers. Where are the checks and balances on what the legislature and what the executive are doing? Essentially, the bill then, as I earlier said, has a stifling effect on litigation and as SANEF has reported, has a stifling effect on free debate.
Isn't that really the issue? Because it's not so much, it might happen that somebody might want to gain access to a document or information and might run into the difficulties that you highlighted in Section 32. But most of us are dependent on investigative journalism for highlighting corruption and other irregularities in state administration. So somebody either being tipped off on the basis of some whistleblower communicating a lead to a journalist, the journalist would then want to report and tell us all about it. And isn't that, as I said to you earlier, the problem? That's where the problem lies. That you have these offenses being created where what is being penalized, if one looks at the wording, is acts of communicating, delivering, making available, etc., state information, which is fairly
Sorry,
nebulous.
Justice, which section are you referring
Section
to?
40, to look at, for example. A similar wording appears in 39, espionage offences, 40, hostile activity offences, and so forth. But look at section 41A. To communicate, deliver, or make available state information. State information is defined. It has the meaning assigned to it in section 5. Section 5 says state information is information generated, acquired, or received by organs of state, or in the possession or control of organs of state. So it's very wide. But the point is, section 41A says this state information, this wide body of information, if you go and communicate it or deliver it or have it with the intention to prejudice the state, whatever that might mean, we can deal with that later, then you commit an offense. And that's the restriction on freedom of expression,
Yes, I do agree with that.
not the classification.
Well,
Because the journalist will get information. He or she doesn't care whether it's secret or confidential or whatever. He wants to disclose it, to tell us about the bridge problem that you highlighted, for example.
I have to disagree with that. I do believe that the classification, and if I can bring you back to the issue of national interest, this concept itself hasn't even been defined in our Constitution. If we're to assume, looking at the preamble of the bill and its objects and its purpose, that where it specifically states that the bill, recognizing the importance of information to the national security, or aiming to promote the free flow of information with an open and democratic society without compromising the security of the Republic, why then has the legislature not constrained Section 15 to those principles and to that object and purpose of the bill? Why has it allowed for national interest, which any executive official, any head of organ of state can use and abuse where they see fit and where they see that
Yes,
it may...
the argument is made, the information that is subject to classification is too wide. Penalties are draconian, and there's a lot of sort of Orwellian speak in the way this bill is drafted. I think that's the point you're making, isn't it?
Yes.
Yes.